application and appeared in the matter of Portland Waste Incinerator, acting through Deborah Collette as Secretary of State for Housing, Communities and Local Government and others.
Yes, Mr. Burton.
May it please your lordships, I appear on behalf of the appellant in this matter. My own friend, Mr. Coley, with Mr. Clapp, appears for the First Respondent, Secretary of State.
Yes.
My own friend, Mr. Elvin KC, with Mr. Wilcox, appears for the Second Respondent, Powerfuel Portland Limited,
Yes.
who I'll refer to as PPL, if I may. The third respondent does not appear, not represented. In terms of housekeeping, my lord should have a core and supplementary bundle, and I should say my instructing solicitors have double, triple checked that my lords have the right bundles. Core and supplementary bundle, replacement skeleton arguments from all of us represented here, a supplemental skeleton argument from me,
Yes.
for which the master gave leave,
Yes.
and also a further supplementary bundle, which I believe has the heading Appellant Supplemental Skeleton Argument Bundle, which is not perhaps quite accurate, but in any event, a further supplemental bundle that's the subject of a conditional application to rely upon it if PPL is permitted to run its argument, which we say is new, that my client's particular nature, purpose means my client cannot show the necessary prejudice.
Wait a minute. We've got the supplemental skeleton,
Yes,
for which you've been given permission,
yes,
and then you're talking about something else.
yes. There's a supplemental skeleton argument bundle is the title. It's a full livre art, it's about 500 pages. In fact, it takes only about 5 minutes to actually go through it to get the point. It may be headed also Ancillary Bundle C, because that's the instruction my solicitors have from the case manager.
Yes.
Case manager.
Yes.
Now, perhaps somewhat unusually, but what I propose to do with that is actually explain it, having put matters in context, if that is acceptable. I do have a structure for my submissions.
Okay. Encouraging.
My estimate is that I will go at least to lunch and possibly 15 minutes more. I'll obviously try to keep to lunch. My learned friends have reserved their position as to whether that will give them sufficient time.
I don't think it would.
I'll do my utmost to keep it to lunchtime.
Well, I would have thought you need to stop at about 1:45. So what is this? What's this about the supplemental bundle?
Well,
So, because the application I'm looking at is the appellant seeks permission to run a supplemental skeleton argument, which I thought you already had.
yes, and there's a separate, well, the application was in two parts. The second part is a conditional application to rely upon the supplemental bundle in the event PPL is allowed to run its argument, which is a new argument didn't run below, that my client's particular nature or purpose means my client cannot show the necessary prejudice.
Because if fuller reasons had been given, it wouldn't have made any difference to your position.
Yes, my Lord Holgate, yes. Yes. So that's what that's about. May I if I get stuck in,
Yes.
and I will explain how that
Yes.
fits together.
Yes.
Thank you very much.
Yes.
So the structure is I want to clearly, by way of introduction, the short point in this appeal is whether the learned judge was right to reject our client's case on a statutory challenge that the first respondent's decision lacks adequate reasoning on a principal important controversial issue. And there's a single ground of appeal for which Lord Justice Lewison granted permission. That's what it's all about. The decision grants permission for a so-called merchant energy from waste recovery facility, also a waste incinerator on the Isle of Portland. If built, it would burn about 200,000 tonnes of waste per annum. It's truly merchant in nature because it's not in any way constrained as to where the waste it takes in would come from. The decision incorporates entirely the report of the first respondent's appointed planning inspector, And because of that incorporation, it adopts all the conclusions of that report. I refer to them both together as the decision. Also, the focus here is actually primarily on the inspector's report, and I'll be clear about the paragraphs in the inspector's report I'm referring to, of course, but as a whole, they are the decision. The challenge, my lords, know is brought under Section 288 of the Town and Country Planning Act. That allows a person aggrieved by a decision of the Secretary of State to grant planning permission to apply to the High Court for statutory review of the lawfulness of the decision. It's essentially a statutory judicial review, but if breach of, quotes, relevant requirements, i.e. statutory procedural requirements, is alleged, then the applicant must show substantial prejudice. That's the wording of the statute. The principles the court will apply are very well known. They're summarised by Lord Justice Lindblom, as he then was in the St Modwin case, which is in my Lord's Authorities bundle, but they are quoted at judgment paragraph 23, which I know my lords have read. I won't go through them in any detail because they are trite. The challenge must be on a point of law, not an opportunity for a merits review. Decisions must be construed in a reasonably flexible way, mindful they're written principally for parties who know what the issues are between them and know that the evidence and argument's been deployed on those issues. So, quote, an inspector doesn't need to rehearse every argument relating to each matter in every paragraph, and the courts rightly deprecate excessive legalism and hypercritical scrutiny in such challenges. The judgment sets out additional uncontroversial principles at paragraphs 24 and 26, which I won't go into. Rounding out the statutory framework, in my Lord's Authorities legislation bundle is Rule 18 of the Town and Country Planning Inquiry Procedure England rules. That's at page 26. We don't need to go there. The short point is that's the requirement for the Secretary of State to give reasons on a decision for a decision on an appeal, and that is the quotes relevant requirement for the purposes of the substantial prejudice limb of Section 288. Now, our case, as my lords know, in a nutshell, is that the learned judge was wrong to find the reasoning adequate. There was an obviously important contentious point that the decision simply fails to deal with. I do put it that high, and my client is substantially prejudiced as a result. And we say that the appeal should be allowed and the decision quashed accordingly. So, by way of a structure.
Can I ask one question? There's reference to a statement of common ground, which is in the supplemental bundle of type 9.
Yes, correct.
My recollection is that when that requirement was introduced, it was initially a policy requirement, but I believe there's something in the procedure rules requiring the preparation of a statement of common ground and what it is to contain, including, I believe, maybe wrong, something about defining issues. Would it be possible to have a copy of that regulation during the course of the day, please?
Yes, I believe that's right, my lord. I will dig it out.
Is my recollection roughly on track?
That's my understanding, my lord. Yeah, we've already said it. Yeah. In terms of structure, I propose to begin by my first topic actually introducing the issue, the principal important controversial issue. Then I'll turn to the legal framework where I'll set out what it is we accept are the elements my lords need to be satisfied of by reference to the case law, and I'll give an outline of our case on those elements, and then I'll make my detailed submissions developing my arguments. With the exception of the legal framework topic, I will broadly keep to the order of our replacement skeleton argument. So to introduce the issue then, and for this in a moment, my lords, I'll ask my lords to turn up the supplemental appeal bundle, which is where the waiting time is. So the judgment itself introduces the issue, as my lords have seen, in a number of paragraphs 63 to 74, and also picks it up again at 81. In short, the issue is whether these proposals complied with a policy WP4C of the waste plan, which required that the proposals support the plan's, and I quote, spatial strategy, including, amongst other things, adhering to its, again quotes, proximity principle. The essential context here is that the Isle of Portland, as the name would suggest, is remote. It's joined to the mainland by a shingle spit comprising a causeway and by Chesil Beach, and it's far removed from the main sources of waste in the relevant waste planning area. The waste planning area is Dorset and Bournemouth, Christchurch and Poole, and the main sources of waste are essentially the urban areas of Bournemouth and Christchurch and Poole in southeast Dorset.
Dorset Council's a unitary authority, isn't it?
I believe it is, my lord. They're both unitary authorities, but
Yeah, you're right.
they share this.
I mean, between them, do
That
they
area.
cover the county, what used to be the county of Dorset? Thank you.
Yes, they do. The Isle of Portland, and indeed the surrounding World Heritage Coast, they're a far cry from those urban areas, both distance-wise and also, of course, in terms of their character. The decision had to be taken in accordance with the statutory development plan, unless material considerations indicated otherwise. There's no dispute that the key part of the development plan here was, indeed still is, I believe, the Bournemouth, Christchurch, Poole and Dorset Waste Plan adopted 2019. So that's in the supplemental bundle, and could we please turn it up, my lords, at tab 2, and in a moment, well, in fact, immediately we'll go to this spatial strategy. It's introduced at page 30 of the waste plan. Say introduced, where you might all see 5 spatial strategy, and reading down the page, 5.1 begins by explaining that one of the key features of the planning system is to ensure that the spatial aspects of development are properly considered. I underline spatial aspect. If my lords have not already read this, I'd be grateful if my lords would read this page. I'm going to take it as read, but just point out what I in my submission requires merits particular emphasis. It says the main purpose of the waste plan is to plan for an appropriate network of facilities to manage the waste arising, to support economic development, and so on. And then it says this at 5.2. So it tells us the waste plan was prepared using the best available evidence to assess current capacity and future waste arisings and need for new facilities, building in sufficient flexibility for changing circumstances, and so on. And then it says this, and I say this is very important because this is what it's telling us what the spatial strategy is about. It says the spatial strategy builds on from the vision and the objectives, seeking to move waste up the waste hierarchy, support the proximity principle, and promote self-sufficiency. That, I say, that's a description of what the vision objectives are all about, and then through making provision for a range of sustainable waste management facilities in appropriate locations, through is what the spatial strategy. That's describing what the spatial strategy is about. And 5.3 explains to achieve this, the waste plans identified in general terms what facilities are likely to be required for the management of the different waste streams and where they will be needed during the plan period. So it's what and where, and it says it underpins the approach to ensure the provision of adequate capacity to manage the expected waste arisings. And then it says, and again this is important, it says the detail and justification for the spatial strategy is provided in the chapters that follow. It doesn't say that the spatial strategy is provided in the chapters that follow. It's the detail and justification for the spatial strategy. It tells us it's illustrated by a key diagram, and that key diagram is towards the back of the waste plan clip, almost all the way at the back actually.
Page 149.
It is indeed, over. Yes.
Sorry, in the supplemental bundle.
It's in the
105.
It's in the supplemental bundle. It's at the back of this tab 105, and what it does. My lords may have a glance at it. It sets out some key waste features really, and what is this red line showing the strategic road network. My lords will notice that the Isle of Portland, which is the bit that sticks out at the bottom, is without a mark. In any event, the spatial strategy itself, if my lords turn the page to Supplementary Bundle 31, is set out in these orangey shade boxes, and what it does is it reminds us at the beginning that the waste plan seeks to remove waste up the waste hierarchy through making provision for sustainable waste management facilities that optimise waste reduction and reuse in appropriate locations. And then it says this will be achieved by addressing the following identified needs, and it goes through the different waste types, and these different waste types and the need that they give rise to is actually discussed in detail later in the plan in section 7. But it goes through the different waste types, and we see, so far as relevant to us, at page 32 of the supplementary bundle, residual waste management, because it's so-called residual waste that will be burned in these proposals. And it tells us it's proposing to deal with that residual waste, the residual waste need, as follows. First, it seeks to concentrate residual waste management development in that southeast Dorset area where Bournemouth, Christchurch and Poole urban areas are. It's approximate to where the waste arises, and I should say much of which presently goes, or at the time of the appeal anyway, goes to a nearby waste site for some intermediate treatment known as Camphor Resource Park, which is marked with a star on that diagram we saw. And it does.
The intermediate treatment is the MBT, is that correct?
I believe so, my lord. Yeah. And it does that through allocations for residual waste management, and that's, I say, clearly in accordance with a principle that I'll come on to, which is the proximity principle. And it also allows for residual waste management development additional to the allocations only if it will, and I quote, achieve a good spatial distribution of facilities, providing benefits, and then with particular emphasis such as a reduction in waste marks, which is that's the proximity principle again. So we've got a good spatial distribution and the proximity principle. Now, as to the proximity principle, I need to just briefly explain that. It's quite an obvious one, that the waste be dealt with as close as possible to where it arises, but I'll quickly point the court to where it is to be found. We need to go back a couple of pages in the waste plan, a few pages, to page 24 of the supplementary bundle. This is a section that begins at page 22 under the heading Guiding Principles, and my lords will see a number of guiding principles: sustainable development, the waste hierarchy, well-known waste hierarchy, and then third and fourth one, self-sufficiency and the proximity principle. And here, my lords will see at page 24, after an explanation of self-sufficiency, at paragraph 315, at 316, we have the definition. And I do say it is certainly a suitable definition of the proximity principle. I know that my learned friends for PPL say that it's not defined at paragraph 40 of their skeleton, but they don't refer to this paragraph there. It says the principle of proximity means that waste should be recovered or disposed of as close as possible to where it is produced, and has been another important driver for the waste plan. So that's what it is. It continues. The waste infrastructure network must enable waste to be managed in one of the nearest appropriate facilities through the most appropriate methods and technology in order to ensure a high level of protection of the environment and human health. So the waste plan is clearly making clear that the proximity principle is discrete. It's a discrete thing. It's an addition different to the other principles, such as self-sufficiency or the waste hierarchy. Moving on through the waste plan, we can see then at page 28, there's these visions and objectives, which my lords also will recall were mentioned in the introduction to the spatial strategy, and the vision and objectives. So we've got the vision at page 28, and then the objectives start thereafter, and objective 2 is the one that's on point here, the second paragraph of that. That's at page 29 of the supplementary bundle, and that begins: waste management facilities should be located in appropriate locations, and so on and so on. Please read. So that's a quick canter through. The desirability of a spatial strategy that's founded on the proximity principle is, in my submission, obvious, because extra HGV miles, what we're still calling HGVs, and HGVs are typically what's used to transport waste, that are an obvious disbenefit in planning terms, or one might call them a harm. They increased traffic is
So the object is
there.
to reduce waste miles.
The object is to reduce waste miles, my lord, and also there's another element which well, it's the same thing, but perhaps just a different way of arriving at that to achieve co-location wherever that's possible. So if waste is already going somewhere, then the ideal is to put another waste management facility at that place, because that is also meant to reduce. The thinking is, well, that will reduce waste miles as well if you can deal with it all at that one point rather than shipping it around. So those are spatial strategy, the principles, and the objectives, so far as most relevant. And then in terms of policies, and I should say I do note that the learned judge described the spatial strategy as policy in her judgment. We are agnostic as to that. I mean, certainly traditionally, no. Traditionally, the policies are the numbered policies that I'm about to take my lord to. The first policy in the waste plan, and the first policy to also say anything sequentially about the proximity principle, is policy WP1, and that's at 25 of the supplemental bundle, and it has this heading: sustainable waste management. What my lords will see, reading down the page to the second paragraph, is that proposals for the development of waste management facilities must conform with and demonstrate how they support the delivery of the following key underlying principles of waste plan. And there are three, only three, and my lords will recall there were more than three set out in the principles section. There are three: the waste hierarchy, self-sufficiency, and proximity. So the proximity principle is given a particular status there. That is then followed by policy 2, integrated waste management facilities, and that's the policy that's very much about the benefits of co-location, in which I should say these proposals were not going on an existing waste site, so they couldn't offer much as regards that. And then the next policy is policy 3, which is for the allocated sites. The policy wording itself is at page 36. The supporting text begins at page 34 and covers about a page and a third. May I ask my lords to note this regarding policy 3, that what my lords will see looking at the second paragraph here is that the words proposals within the allocated sites listed below will be permitted where they are in accordance with the allocated uses, set out the insets, and where it's demonstrated they all meet all of the following criteria. So that is, by its wording, it's a permissive policy. Will be permitted if, and the reason I flag that is because there's a difference between that and the policy that we're about to look at, which is policy 4. So policy 4, which is what this appeal is very much concerned with, is about applications for facilities not on allocated sites, and that policy is it's a restrictive policy. As my lords will see at page 40 of the supplementary bundle, it begins: proposals for waste management facilities on unallocated sites will only be permitted where it is demonstrated that they meet all of the following criteria. That's why I say it's restrictive, will only be permitted, and then you've got to meet the 4 criteria. And we can contrast that with the permissive language of WP3. There are these 4 criteria, and my lords, I'm sure I've read them already, but if not, please do read them. It's criteria C that in our submission has been missed by this decision here, in the sense that the issue under it had not been dealt with. The proposals support the delivery of the spatial strategy, in particular contributing to meeting the needs identified in this plan, moving waste up the waste hierarchy, and adhering to the proximity principle. Now, of course, I don't ignore the first two limbs there, after in particular. They are contributing to meeting the needs and moving waste up the waste hierarchy. But the third one, which is where I very much base my case, is adhering to the proximity principle.
I mean, the allegation of a failure to give adequate reasons relates to the proximity principle.
Yes.
And that alone.
It doesn't relate to contributing to meeting the needs,
Yeah.
and it doesn't relate to moving waste up the waste hierarchy. Correct. The only nuance there is that it's bound up also with it's supporting the delivery of the spatial strategy. ... In particular, ... adhering to the proximity principle. Yeah.
Does 4C
Yes.
add anything to policy 1?
Well, it does, yes, because firstly, my lord, it binds in the spatial strategy to the proximity principle. So as a package, and the spatial strategy, as I've shown, my lord, wants it seeks, certainly for residual waste, a good spatial distribution of facilities, which is an aspect of the proximity principle. But it seeks that good spatial distribution, and then we have the in particular adhering to the proximity principle. And because it's a restrictive policy, and specifically for the non-allocated sites, in my submission, it has a particular importance in a hierarchy when there is an application for development on a non-allocated site. So I certainly accept that there's an awful lot of overlap between the two. I do accept that. I'd just say this has something a little bit extra because it's referring to the spatial strategy, and it's specifically for those non-allocated site proposals. I do also say, my Lord Nugee, that this WP1 is equally, and this is why I do put the case on this basis quite carefully, and that's going to Narin. This is why I do so. WP1 is equally not the subject of reasoning on this proximity principle point from the inspector in the inspector's report.
Thank you.
Now, may I ask, my lord, whilst we're just looking at WP4, to note the difference between limb criteria C and criteria A. Criteria A, and we say, as regards criteria A, which has two limbs, the first limb is there is no available site allocated for serving the waste management need that the proposal is designed to address. I just pause there. That the PPL could never claim that here because there were allocated sites for.
It does say
this
available.
Available. Yes, equally, but there was no suggestion from PPL that they could claim that limb.
It's not simply saying the mere fact there's an allocated site is sufficient.
No, absolutely.
But there's the question as to what's meant by availability. But you say that wasn't gone into here. Okay.
No. I mean, no, because there was the Camford allocation, there was the Parley allocation in particular.
Question which might go into available is whether or not you're going to get planning permission.
Might do, my lord. That wasn't the basis on which it was
Overtones the deliverability about it, isn't it?
Possibly, but in this appeal, everyone's under criteria A, everyone's focus was on could these proposals show, and this is the second limb, advantages over the allocated site, and that under A that was the battle. Now, it's a very different criteria from C, not least because it is all encompassing. The advantages can be, as long as they're material in planning terms, can be anything effectively, and it's so it's about different things.
But it could include presumably the proximity principle.
It could include that, my lord. It could, but it could also include all sorts of different things like impact on heritage assets or not, or and having just shown, I hope, my lords, the conceptual difference between the criteria A and the criteria C, may I make this point about C, which is relevant to the arguments here. C is, in my submission, is clearly not satisfied simply if there is an identified waste capacity gap that a proposal will meet, because the requirement to support the spatial strategy and in particular adhere to the proximity principle means more is required to comply, simply than saying my proposal for X tonnes per annum will meet your capacity gap of X tonnes per annum. Now, I want to introduce a point here regarding the spatial strategy, which I'll come back to, and the point is this, that what is, and I emphasise is, the spatial strategy is something over which there is now controversy in these proceedings, but in my submission there was not controversy before the inspector, and I say that PPL has changed its position regarding what is the spatial strategy since the planning appeal. I will come on to explain that at a logical point. Now, in terms of the origin of the decision, and of course where ultimately this issue sits and began, the decision was on PPL's appeal against Dorset Council's refusal of planning permission on the 24th of March 2023, and the refusal was for 3 reasons. And could I please ask my lords to turn to the refusal, just so we can absorb this point with the document in front of us. Unfortunately, so it's SP 113. Unfortunately, it's been split between 2 pages due to a copying error, but it's actually 113 that is really what we need. This is the refusal, and of the Dorset had 3 reasons for refusal. Of those, it's the first reason for refusal that is our focus.
I'm sorry to be slow, but I've got 113.
Yes, my lord.
And I haven't got a 114.
No, indeed, I'm afraid a copying error,
We
my
haven't
lord.
got reasons for refusal
Has-
2 and 3.
They are at 343. They are at 343, my lord.
343.
Yes.
Okay.
Well, we
342.
sorry, my lord.
Ah, yes. Thank you.
Is it 342? I apologise. Yeah.
Well, a lot of your page references are 1 out compared to the bundle we've got. I think we've been able to cope.
Oh, yes. I'm sorry, that is one of them. There was an unexpected shift by 1, and I've missed it. Sorry. Yes.
Don't worry, it doesn't matter.
Thank you. Yes, I'm afraid that, yes, so that has the very last 2 lines of the first reason for refusal, which is primarily why we need it. Just reading to the words, my lord. The proposed development being located on a site that's not allocated in the waste plan fails to demonstrate that it would provide sufficient advantages as a waste management facility over the allocated site in the plan. Now, now what we have now, I say very important words. This is by reason of its distance from main sources of Dorset residual waste generation and the site's limited opportunity to offer co-location with other waste management or transfer facilities. Now, according to that, I say that is all spatial strategy and proximity principle stuff. And it then continues, which, when considered alongside other adverse impacts of the proposed in relation to heritage landscape, then it would be an unsustainable form of waste management. It says, as a consequence, it would be contrary to policies 1 and 4 of the plan, and also para 158 of the then NPPA, plus the 2021 NPPA, but we don't need to worry about that, paragraph 158. So we had the first reason for refusal 1, that amongst other things, I accept, that amongst other things, embraced the issue, and the other 2 reasons for refusal, which my lords can see, were concerned specifically with impacts on heritage and landscape. Now, of course, PPL then appealed, and I'll come on to this in a moment, the state of the common ground between PPL and Dorset, and then the evidence from the parties in my submission made crystal clear that it was a principal important controversial issue whether the proposals supported the spatial strategy, in particular by adhering to the proximity principle, as described by W4C. So that's the issue. What's pertinent just at this stage is to register that after the reasons for refusal, after PPL had appealed, Dorset Council then added a new point, a different point, to its case, alleging that there was in fact no, quote, capacity gap or raw need in the waste plan area that would justify this proposal. It said, and it was clearly a very difficult argument to run, it said, well, the waste plan has this figure for residual waste need, that's too high, it's reduced. Of course, it was difficult to run because the waste plan was founded on that waste figure, so far as residual waste allocations and so on were made. But anyway, that was the new point they advanced. It's very important to bear in mind that that was a different point. It was in addition to reason for refusal one, and that's crucial. Separate to it, in addition to. So I'll come on now to the framework. Of course, my lords know, crux of our case on this appeal is there is no reasoning on the issue, and certainly no adequate reasoning on it. And my client, which, as I'll show my lords, had run this issue hard in evidence, is completely nonplussed. It thought it had a trump card, and it gets nothing in the decision about it. And we wonder, as my lords know, whether the inspector even understood it was a controversial issue, even understood it was an issue. There's substantial doubt as to that, as well as whether he got the application of the policy matrix right, or a mixture of all those things. So, second topic, what we accept, my lords, need to be satisfied of, a reference to the case law. The framework is this: we must satisfy, we accept the courts of my lords of three essential elements. First, that the issue was a principal, important, controversial issue. Second, that the decision lacks adequate reasoning on the issue. Third, that my client has been substantially prejudiced. Briefly, as to the first element, we say the learned judge quite clearly proceeded on the basis the issue was a principal, important, controversial issue. See Judgment Para 104 read in context. Of course, my learned friend skeletons, they don't dispute that. We say the judge was right to do so, and there's no respondent's notice contesting it. So what they shouldn't be attempting to do, my learned friends, is to argue against or dilute that principal, important, controversial issue status, which we say in reality is what their skeletons try to do. So I will, to ensure it's bolted down, as it were, I will canter through why the issue was a principal, important, controversial issue in the course of providing the necessary context for the second and third elements. I'll come to that. In terms of the law on those three elements, this is all quite familiar stuff. It's in our skeleton argument at paragraph 49 onwards. It's been considered that the requirement for reasons has been considered at the very highest level a number of times, in particular in Save Britain's Heritage and Number 1 Poultry, in South Mucks and Porter Number 2, and in Dover District Council and CPRE, all of which are in the authorities bundle. The general reference point, the starting reference point, is generally Lord Brown's summary in the South Bucks and Porter case. Could we please take that up very briefly?
It's all agreed, isn't it?
So it's so familiar. I'm
not
very
sure we
happy
need
to just
Yeah.
just race through it. So I'll take that entirely as read. I hope I won't be criticised by learned friends for not reading out bits of paragraph 36 of Porter. Equally, I fully acknowledge and I absolutely rely upon this, that Lord Brown noted it was that the observation of the then Master of the Rolls in Clark was felicitous. He boiled the issue down to whether the decision of the Secretary of State leaves room for genuine as opposed to forensic doubt as to what he has decided and why. An issue to be resolved as the parties agree on a straightforward, down-to-earth reading of the decision letter without excessive legalism or exegetical sophistication. Of course, it's only a summary what Lord Brown said at paragraph 36 of Porter. I do say that to really understand and get into some of the deeper thinking about what is sufficient to raise substantial doubt as to whether the decision maker in law, we need to go to the observations of Lord Bridge in Save. again, it is very familiar stuff to my lords. I know. I won't take my lords to it particularly because it is so familiar, but I'll simply just remind the court perhaps that Lord Bridge very helpfully put things in the sense that, of course, reasons have to be proper, intelligible, and adequate. If they're improper, they'll reveal a flaw in the decision-making process that gives rise to another ground of challenge. If they're unintelligible, well, that's like giving no reasons at all. The difficulty is with whether they're adequate. He did use the language, Lord Bridge, of deal with the substantial points that have been raised, as well as referring to what conclusion the decision makers reach on the principal important controversial issues. So we've got a couple of slightly different ways of describing the status of the issue. He said that the matter is approached by asking this single question, which is whether the interests of the applicant have been substantially prejudiced by the deficiency of the reasons given. As my lords know, Lord Carnworth doubted whether it was actually correct to truncate and really fold everything into a single issue like that in C. Perry Kent, but he explained the context, and that was really Lord Bridge was saying this in the context of reminding everyone that it's for the applicant to show these things. That's where the burden lies. These various different formulations in Save, Lord Bridge speaking of the substantial points that have been raised and the principal important controversial issues. In Porter, Lord Brown said there's no need to refer to every material consideration. Clearly, the issue has to be substantial, it has to be controversial, otherwise I'm not going to persuade my lords to engage ultimately, and I say I can show that. In terms of the adequacy of the reasoning, I'm very happy to rely on the observation of the then Master of the Rolls in Clark. Does it give rise to a real, as opposed to a forensic doubt as to what has been decided and why? By way of an introduction to our case on that, come on to it, by way of an introduction, this planning inspector was he was scrupulously careful to show everyone what he's dealing with in his report by in particular using bolded internal references for important points back in his report, including the parties as he'd recording the parties' closing submissions. And I'll come on to this, but I say that it shows that the text that the judge is relying on as addressing this issue is clearly not addressing this issue, and he's actually been really clear, the inspector, about what he's doing and when. And another point I just want to introduce here to my lords, and I will come on to it, is that the Secretary of State on this challenge has run a case from the summary grounds of resistance onwards that this issue wasn't an issue in its own right at all, that it was folded up with a capacity gap issue, and then went even further in oral submissions to the judge below and said it had actually been conceded. The issue had been conceded by the time the inspector came to write his report. It's all wrong, but it's actually the case that the Secretary of State is telling us in the clearest possible terms that the decision maker here misunderstood that this was a controversial issue, and that's why there's no reason for that. I will come back to that. In terms of the third element, the substantial prejudice element, we absolutely accept that the case law speaks repeatedly in terms of substantial prejudice. We say, and this is our supplemental skeleton which sets out a bit of the detail here, we say that's because of the wording of the statutory test combined with the statutory requirement to give reasons. And we do doubt the correctness of that test in a case with facts like this. Obviously, very important issue whether or not an incinerator or waste plant goes on the Isle of Portland. We say this is a case where at common law reasons would have been required for the decision in any event. But we are not so unrealistic as to base our case on the assumption that I will persuade my lords to distinguish Porter and the other cases and find that there is not, on the facts of this case, a requirement to show substantial prejudice. I'm going to show my lords why we can
So you're not
satisfy.
pursuing that point that there's a common law distinction?
Well,
Because I've got, if I may, I've got one short question to ask on that.
please do, my lord.
Lord Carworth makes it clear in Dover
Mm.
that that approach is based on a duty to act fairly.
Yes.
It is trite law that there is no breach of a duty to act fairly unless there's substantial prejudice. See, for example, George and the Secretary of State, Hopkins and a host of other authorities. So what's the difference?
Well, my lord, the High Court, as my lord has seen, my lord has clearly read the Martin case and the
But sorry, there's a short point.
Yes.
If one's basing the duty to give reasons on the duty to act fairly, doesn't the common law require substantial prejudice for any allegation of unfairness?
Well,
Otherwise, it's hollow.
my lord, I accept it requires some prejudice, but
Yeah, okay.
but I don't go as far as substantial prejudice.
I
And
understand.
yes, thank you, my lord. So
Was this not a challenge brought under Section 288?
yes, it was, my lord.
Well,
Yes.
doesn't 288 itself say you need substantial prejudice?
Of course it does, my lord. Yes,
So
of
how
course.
can you now turn it into a common law challenge?
My lord, the issue there is the source of the requirement to give reasons, and I say,
Well, if I can try and help,
I'm trying not to-
there's been a lot of debate on this 30,
Yes.
40 years ago in the House of Lords.
Yeah.
The other limb is not within the powers of the Act, and
Yes.
sometimes it is said a breach of a duty to act fairly renders the decision ultra vires, not within the powers of the Act. But it would be astonishing if Parliament has created a different approach to the duty to give reasons, depending upon whether it's common law or statute or powers.
my lord, I don't want.
Go as far as accepting there's got to be some prejudice.
I do, yes, I do, my lord. I don't want to spend time on this because I say we can show substantial prejudice, but yes,
You need to get onto the
I
meat.
need to get on to the meat, and I will. The test for substantial prejudice, I say, is best found in I say the test. Examples of substantial prejudice are best found again in SAVE, and this again, if this is totally familiar to my lords, I won't go there specifically, but I would like to go there just in case it isn't. Page 46 of the authorities bundle is where Lordbridge discusses what he describes as essentially these are he describes examples of what is when normally, he says normally is the word he uses, prejudice, substantial prejudice would arise from one of three causes, and that's it's at internal page 167E of the report itself. And we can see, on my submission, but from the word normally, it's clearly not an exhaustive list, but nonetheless it's sufficient for my purposes. He sets out three causes of substantial prejudice. The first, as I say, I'm at authorities bundle page 46, down at the bottom of E. So normally such prejudice will arise from one of three causes. And first, I'm relying, my lord, on the first and the third, if necessary. But I very much rely on the first and the third. So the first, substantial prejudice to a developer, obviously we're not that, whose application for permission has been refused, or, and this is what I rely on here, or to an opponent of a development where permission has been granted, where the reasons for the decision are so inadequately or obscurely expressed as to raise a substantial doubt whether the decision was taken within the powers of the Act. Now there are various possibilities here, but the one that really does stand out, as I said, based on what the Secretary of State has said throughout these proceedings, is that the inspector simply, and there are reasons why this would have been the mistake, the inspector simply failed to grasp this was an issue, or rather thought it had been conceded and just fell with the need capacity gap issue when it didn't. So that's the first cause. I say we come within that. And over the page, just providing a little bit of further thought or example regarding that first cause. Lord Bridge says at C to D over the page, so this is internal page 168, if it was necessary for the decision to resolve an issue of law and the reasons do not disclose how the issue was resolved, that would suffice. If the decision depended on a disputed issue of fact, and this is what I rely on, of course, and the reasons do not show that issue, how that issue was decided, that may suffice. So that's the first cause. The third cause, going back a page, is thirdly, the words, an opponent of development may be substantially prejudiced by a decision to grant permission in which the planning considerations on which the decision is based, particularly if they relate to planning policy, are not explained sufficiently clearly to indicate what, if any, impact they may have in relation to the decision of future application. That is, and there's a little bit more about Lord Carnwath picks that up, third cause up in the Kent case at paragraph 45, but I don't believe we need to go there. It's there in relation to the third cause, where, and now we come to it in context, the new argument that PPL raised, which is paragraph 81 of PPL's skeleton argument, that new argument becomes relevant, and our conditional application to rely on this further supplemental bundle comes into now context, because what PPL says my client can't by definition be substantially prejudiced because essentially its particular nature purpose is all about resisting this planning permission, and so it can't fit into Lord Bridges' third cause of substantial prejudice there. Now, of course, on that I say, well, firstly, we fit into the first cause anyway, so that doesn't work for PPL. But in any event, as regards the third cause, I say it's a new argument. If it had been raised below, we had lots of things to say about it and evidence to bring forward, which is what's in the supplemental appeal bundle. And that supplemental appeal bundle, which is why I conditionally apply to rely upon it, shows that my client, although it had started out when it was founded, yes, it started out as founded in opposition to this proposal, well before even Dorset's refusal, its activities and interests had become much more wide-ranging across a really broad scope of environmental and planning issues. And it wasn't at all any longer just about resisting this planning permission. So that's how that application fits in. That's why it's made. What I suggest we do about it, if my lords are amenable, is if my lords allow PPL to run its argument, then in reply I will briefly give my lords a list of the references, and that's I'll make my application to rely upon it, and I'll briefly give my lords a list of the references.
Thank you.
So in any event, I've gone through the three elements. I say that we satisfy them all. In the circumstances, I submit that although my own friend Mr. Elvin Casey for PPL seeks to rely on simplex, I say there's no scope for simplex to operate in practical reality, because once one has passed over those three hurdles, what space is there for simplex realistically to operate after that? And that is discussed, I say pertinently, in the High Court decision that I accept, but the Tijuana case that's in my Lord's Authorities bundle. And it's in particular paragraph 96. Perhaps we could just look that up, because that's it's perhaps not the most explored of legal concepts, unlike many of the others that we have looked at.
What page?
So 226 in the authority funded
Thank you.
case. And this, of course, is another statutory review. Now, and it's under this heading relief, but the nub of it is paragraph 96. And paragraph 96, Ms. Cross is there, explains, and picking up from in light of, the sentence that begins in the light of, having just said that the preconditions for relief are present, and those include the fact of substantial prejudice to the claimant having been established, in light of that, it will only be a rare case where it will be appropriate for the court to decline relief in its discretion. The principal protection against artificiality lies in the high hurdles which have to be surmounted for a reasons challenge to succeed, and that clearly that must be wrong, because simplex, meaning the decision must show the decision would necessarily have been the same, and the judge completely accurately summarises the law there, and all parties are agreed on that in our judgment here. If as the claimant, or the applicant rather, one gets over element 1 and element 2 and element 3, how realistically can it be said that the decision would necessarily have been the same?
Well, without spending time on this,
Yes.
it may depend upon the nature of the flaw and the reasons. If, for example, the court accepts that the reasons are inadequate because they may conceal a public law error, we might say, well, what if the decision maker did make the public law error? The judge may be in a position to say it makes no difference to the decision. So in that situation, I can't see why the analysis would be any different for a reasons challenge. On the other hand, if it's Lord Bridges' third example, where a claimant is entitled to know what the implications of the decision are for future decision making, then the analysis would be different. I could see there might be difficulty in applying simplex. But maybe we ought to see where we get to.
Yes, I think we should. I accept, my lord, everything, of course, turn on the particular flaw or flaws as found. Anyway, that's my submissions on the legal framework, my lords. I now want, for my next topic, to put the issue in the context of the planning appeal, and I am proposing, because of the way my learned friends have run their skeleton arguments, I am proposing to, just as I say, introduce and explain why this was a principal, important, controversial issue. If my lords are happy with that and want me to move on from it, I gladly will, because it's going to take a bit of time. But
No.
I'm going to
Yes.
do that. Thank you. I'll take matters chronologically, and I make, brace myself, my lord, 9 points in all. The first point, which I've already introduced, is the fact of reason for refusal 1 itself, as I've explained. Amongst other things, it embraced the issue. The second point is that, and this is important, it's something that the Secretary of State in his skeleton seems to be consistently rather overlooking. After the appeal was made, my clients and the Portland Association were given so-called full Rule 6 status under the inquiry procedure rules. And so as such, they were full parties, and they tendered evidence, and they had, they actually ran a joint case. But that by the by. In terms of the rules, they had exactly the same rights and responsibilities as PPL and Dorset here. Call evidence, cross-examine witnesses, call others, and make submissions. They weren't merely bodies that spoke at the inquiry. I'll come on to, but the Secretary of State skeleton just really fails to appreciate that separate status, quite distinct from Dorset, and that they led their own evidence. The third point, and this is one that concerns Dorset, is it maintained reason for refusal 1 throughout, and the issue was crystallised in the statement of common ground quite early on. Now, my lords may already, I know from comments, have looked at the statement of common ground. Please could we turn it just to see this? And for this we go clearly to first to supplemental bundle 244. So it's the main statement of common ground, and then at page 244 we see this paragraph 7.14. It sits under a heading that is back on the previous page, Waste Plan Policy 4.
Yes.
714 says, having gone through, my lords will see the other criteria A, then B, it says this: the appeal proposal's ability to meet other provisions of the development plan in respect to waste strategy policy 4 criteria C and other development plan policies, and this goes on to D, is not agreed, it's covered by the area of dispute below. So it's clearly flagged as something not agreed, and on we go then to find out what's said about it. And we go on to the areas of dispute table that starts at page 252 of the supplementary bundle. It's paragraph 7.55 is where it starts, and it's a
That says that these are the main areas.
it does indeed, the main areas of dispute. So this is, I say, important stuff. And then on to page 254, 253 really, I suppose. We have unallocated waste sites, waste plan policy 4.
Sorry, where are you again?
Sorry, 253, there's a discussion of waste plan policy criterion, for waste plan policy 4 criterion A, my lords will see.
Yes.
Yes.
Thank you.
Then there's a new topic, sustainable waste management, and that begins by first of all talking about policy 1, and then we come to, in particular, waste plan policy 4C. My lords can see it is specifically referred to in the PPL column on the left that Dorset Council then respond to in the column on the right. And so that's the top of page 254. Policy 4C is introduced along with policy 6, which is one of our specific types of proposals that also apply to these facilities. But policy 4C is introduced, and then we have these 3 rows where, in my submission, the council is very clearly setting out a case that makes clear that the issue is a main issue. And I'd be grateful if my lords would read those rows. And really, the top box actually captures things really quite well. The council's considered that its allocated sites, principally located around the southeast Dorset conurbation, the location of the majority of residual waste arisings are near to the Camford MBT plant, are preferable for meeting Dorset's residual waste management needs, accord with the planned spatial strategy would minimise waste demand. So there we've got our issue. Spatial strategy, proximity principle, the reference to the waste demands, of course.
So when the council are applying criterion C to the facts of this case, they say it can be looked at in terms of whether the allocated sites are preferable to the proposal.
Well, that's
in other words, it invites a comparison.
There is a comparison element. I do accept that, my lord.
To be read.
Yeah, no, I accept that, my lord. What of course I don't accept is that one can duck out of the criterion C test by working through criterion A, and not unless working through criterion A by a side wind, as it were, one is asking and answering the specific questions. Does this proposal, does it support the spatial strategy, in particular adhering to the proximity principle? So yes, I accept that, my lord.
And when you apply the proximity principle, do you also take into account where the waste is going at the moment?
Not when applying C, looking at supporting the spatial strategy, because the spatial strategy is not about where the waste is going at the moment. The spatial strategy is about the waste being envisaged to go to these places, these allocations, and so one has to. And if one isn't there, if one's falling into the residual limb of the spatial strategy, the one I took my thoughts to, outside the allocations, does it achieve a good spatial distribution of facilities? So, and clearly that was a point that Dorset made at the inquiry and in its closing submissions, and that was a bone of contention. It's not one that the inspector actually dealt with between the parties, but that was a bone of contention. But Dorset made its case very clear that one has to look at the spatial strategy to ask whether the proposal is supporting the spatial strategy in terms of the proximity principle, not at what is happening now. So the comparison was between spatial strategy and the proposals, not what's happening now and the proposals. That's it.
Well, I'm not sure I understand the last bit, because presumably a purpose of the plan when it was drawn up was to stop waste going outside the county.
That's the self-sufficiency.
That's why you have the allocations.
Yes, but that's the self-sufficiency principle, of course.
But it's not. Is it really distinct from proximity and reducing waste mileage?
I accept they blend together.
They do a bit, don't they?
Yes, they do. I do accept that. Yeah. So the issue is there as a main issue in the main statement of common ground. That is just between Dorset and Powerfuel, though, and that is so important here, because my client and the Portland Association had their Rule 6 states in their own right, and what they did, and this is my fourth point, they gave very full evidence that these proposals couldn't comply with the spatial strategy or the proximity principle. And this is Miss Toulay's proof of evidence, and she spent a considerable chunk of her proof of evidence on this. We've obviously only got the extracts. If my lords could turn please to page 184 of the bundle. I should say her proof begins at page 179, and what you can see at page 180 is a contents page, which is helpful. We can see that she starts getting into the issue quite early on, and begins indeed at page 182 of the bundle at 2.4 by pointing out. She says this. It's hard to understand how building a waste incinerator that is not part of an integrated network that's stuck out on a limb with no proximity to the existing network of waste disposal and recovery installations of Dorset. She says that clearly doesn't comply.
So sorry, could you give the page again?
Sorry, 182, my lord.
Yeah, and it was 2 point.
It was 2.4.
Oh, I've got it. I'm sorry.
I'm just making the point here that she says above, the focus of my evidence in respect to the waste plan is policy 1 and 4, as well as referring to policies 2, 3 and 6. Anyway, I introduced that 2.4 because of essentially the complaint she makes, the substance of it is very much about, it's very much about the issue, although she's referring to objective 4 aims, but quite clearly touching on many of our points. And she then comes on, turning over to page 184, she discusses conflict with policy 1 of the waste plan, and can my lord see please at page 185 the supplementary bundle, para 2.15. Essentially she says what I've just read again, but now she's put it very clearly against proximity. And then if my lords haven't already, could I ask my lords please to read from 215. Effectively, it's all on point, or almost all of it, as we go through these paragraphs, including then continuing in, as my lords will see, at page 187 to conflict with policy 4. And what Ms. Dooley does is she works through the criteria as one would expect, and as to criteria C, that is found a few pages on page 190, paragraph 2.36. She sets out the criteria. She then sets out the key diagram, explains there's nothing shown at Portland. There's a marker at the nearest town of Weymouth, but it's a key town where no specific local waste management needs have been identified. And she goes on, and it's all the issue. We do summarise, Mr. We summarise Mr. Hughes' evidence.
You're emphasising on your page 191.
Yes.
Which conveniently summarises what's in the plan.
It conveniently summarises what's in the plan, my lord, and then Ms. Toulay says 239, Portland is not in South East Dorset. It doesn't meet that criteria. She's referring to the primarily addressed through new capacity in South East Dorset. In the context of the BPC and Dorset areas, Portland offers no benefits.
So if I followed,
yes,
it says what it says,
yes,
but it's not addressing the issue as defined by the council and the statement of common ground.
It's not addressed. Sorry, my lord, I'm not.
Well, the passage you just took us to.
It's certainly putting things in Ms. Toulay's and my client's own particular way.
Yes. I understand. Thank you.
Yes, it is. And one of the, well, as my lord knows, one of the things we are very concerned about here is that essentially our argument, which we say did fit with it, it fit within it. It's very closely allied to the way the issue was identified in the statement of common ground. But the point we're making is you just can't claim a proximity principle adherence from this facility. How can you? It's 39 miles away from where the waste arises, and where it's dealt with at the Camphor Waste Management Centre. In any event, we summarise her evidence at paragraph 21 of our skeleton argument for ease of reference, but there it is. There are two points about the Secretary of State skeleton argument the Secretary of State gets wrong, and they're really important points in my submission. The first thing is the Secretary of State does not understand who gave the evidence for my client and the Portland Association. Could my lord please look at the Secretary of State skeleton argument, which is the core bundle at 43. If you want to have it separately, it's para 4C with its footnote 4.
Sorry, para
4C.
C, yes.
With its footnote 4. And my lords will see that the Secretary of State says Miss Hart and Mr. Potter were my client's witnesses. Do you want to see that from
yes.
the combination of those? They weren't. They were Dorset's witnesses. And what the Secretary of State then does, my lords will see, having read through the Secretary of State skeleton, is when the Secretary of State is setting out what is described as context, in terms of the evidence, what the Secretary of State does, and this is its para 43, it doesn't mention Ms. Toulay's evidence at all. Okay, it's all
The
about
skeleton.
Yeah, it's
maybe the skeleton's wrong in that respect.
No.
The proceedings are reviewing the inspector's report.
reports. Yeah. I'm flagging. I'm making sure. I know my lords have the point, but Ms. Toulay gave the evidence for my client. There's also, I say, mischaracterisation of what Ms. Toulay is saying. But my lords have seen what Ms. Toulay is saying now, so I don't need to go into that. The fifth point I make, though, is that in any event, Dorset's evidence from Miss Hart and also Mr. Potter, but Miss Hart was the planning witness, so she sat at the top of the evidential tree, as it were, for Dorset. Gave very similar evidence to Miss Tooley on the issue. My skeleton at paragraph 22 gives the references. I don't propose to go through them in the same detail as we went through Miss Tooley's evidence, but perhaps we could I just take my lords to show the framework really of how Miss Hart went about it. And for that we need to go to page 207, which is where her proof is. And then having found that starting page, page 212, and you'll see that she sets out a heading at supplementary bundle page 212, main issue 1, compliance with policy 1, policy 4 and policy 6, the spatial strategy, self-sufficiency and the proximity principle.
Sorry, give me the page number again.
212, my lord.
Thank you.
And para.
It's all of these paragraphs, my lord. That what I'll highlight that she makes clear that the basis for reason for refusal 1 is the appeal proposal being on a site not allocated fails to demonstrate it provides sufficient. She's reciting reason for refusal 1, sufficient advantages over the allocated sites by reason of its distance from the main source of Dorset's residual waste generation and limited opportunity. So it's the reason for refusal 1 again. It's essentially quoted there, and then she goes on to explain, and she tackles WP 4 and WP 4C specifically in the paragraphs that follow, and she has it's many paragraphs, but she has specific sections dealing with the proximity principle. It's a long down of paragraphs that starts at page 217, and they run all the way on.
Just before you get to 217, page 216, page 37, she refers to the council's updating of the capacity.
Yes.
So that's in there as well.
It is in there as well. She is. I entirely accept. She's mingling and mixing lots of different things, including capacity.
Well, that's what happens in planning sometimes.
Yes. In any event, I'd be grateful if my lords would read this. What I would just highlight is that main issue 2, 219. That's then a different topic. That's where compliance with policy 4, she's dealing with claimed advantages or benefits of the appeal proposal, and that's where we see her conduct the WP4A exercise as she understands it. She's obviously comparing the appeal proposal against the allocations. Now I have also in our skeleton argument, we have also given my lords the references to Mr. Potter's proof. I don't have time to go through those, but I'd like, if my lords do have time, my lords to consider those references. The 6th point I make is that PPL also addressed the issue in its evidence, and it's very interesting to see what its planning witness, Mr. Roberts, said at 154 in the supplemental bundle. What Mr. Roberts said at his paragraph apologies. So
You just want to give us the paragraph number.
sorry, can I just pull? Sorry, I've just apologies. 172. Sorry, 171 and 172. Apologies, I lost my reference to that.
PPR 170, 171.
What paragraph number?
So I'm going to para 4.318.
Okay.
171, and then 4.4.C over the page. 4.4.C at page 172.
Thank you.
What I'm drawing my lord's attention to is that Mr. Roberts gave what I submitted rather striking evidence. He said that the focus of the spatial strategy will need to shift to accommodate these proposals.
Yeah, but you have to read that in the
Of course you-
context of 4.3.17, which we've read.
Yeah, absolutely, you do, my lord. But my point is, Mr. Roberts was well aware and is addressing it head on that the spatial strategy was an issue. Of course, he was saying we're in accordance with the spatial strategy. I'm not seeking to somehow claim that he was agreeing with the council and saying you're not in accordance. But he does focus specifically on it. There's this striking evidence that he gives. It's all very much, I say, consistent with the issue being a principal, important, controversial issue. And we then had, I've got the reference to it in the skeleton again, chronologically Miss Hart's rebuttal proof, which came back to it. Then we come to the closings, where there's a great deal of controversy in these proceedings. This is my 7th point. But the point I make here, and for this we can stay, in my submission, we can stay in the inspector's report for this, because he was clearly taking a very detailed notes as things were going on, and he's got the closings down in very detailed form.
Well, the closings are in written form. This is a common technique of public compliance, if I can correct
Is this, my lord? Yeah.
It's electronic and it gets lifted into the inspector's report.
Yeah, but he's also yes. He's also, though, there are some. It's in his own words though. It's very full, but it's in his own words, and that's it's no. What he hasn't done is giving you your closings in Word, and I'll cut and paste them in. 7.62 is where he is. He's setting out here my client and the Portland Association's closings, the bit of theirs concerned with waste and climate, and what he's recording here. The Rule 6 parties have concerns about the client's compliance with the ERF with the waste plan and support the council's evidence as to why the ERF would not comply with policy 1.6 therein, and then it proceeds. Point is, what my clients were doing there is they are supporting they're supporting the council's evidence. They went first in closing, and it's a confusing point that the inspector sets out the closings in order Dorset, then my client, then PPL. And frankly, I worry we submit that there's a very real doubt as to whether or not the inspector somehow forgot who'd gone first, because it was my client who went first.
Are you saying that he's missummarised your client's case?
No, that is no. I'm not saying that. I'm not saying that, my lord. What I'm saying is, what he correctly understood here from the closings is they were given orally, of course. Yes, they were in writing, but they're given orally. My client is adopting Dorset's evidence on the issue. It's not adopting Dorset's closing, which hadn't yet been given, which it hadn't even seen. And the Secretary of State in my submission does take us down, and took the learned judge here down, trying to take the learned judge here down a rabbit hole about that. My client is standing full square behind the evidence, which is all about the issue, and I say consistent with my client's evidential case on the issue. And the concern I express, my Lord Holgate, is, and I do say this is a point that fits into the substantial doubt. It is the Secretary of State keeps telling us in this case the issue was conceded. It was conditionally conceded. If you lost on the capacity gap issue, then this issue was conditionally conceded. Well, not by us, it wasn't. Whatever one takes from Dorset's closings, and I say one can't actually take what my learned friend for the Secretary of State ties to take, but whatever one takes from Dorset's closings, they came after ours, not conceded by us. Can I
Sorry,
also?
can I just
Yeah.
make sure I'm keeping up with you? Is it right to say that in your client's written closing, there was no reference to the policy 4 issue?
That, my lords, that is in the written closing, sorry, that, what we have there at 7.62
Is what we get?
that is what we get.
Wasn't in the written document.
That is, so this.
Is that correct?
Yes, my lord, this is,
So really, what we need to focus on is, if I understand it correctly, is what was said by Ms. Tulay in her proof.
yes. Yeah, but as my lord knows, inspectors always tell parties not to repeat. And some parties might take that more seriously and literally than others. We were a party who took it literally and we didn't repeat. But can I point this out? And I do rely on this. What the inspector says at the start of each of these summaries of the recordings of the closings, so at 7.1, is, and this is repeated for all the parties, so core bundle 413. He says the case for TPS and SPWI, this is set out in full in opening and closing statements of inquiry and in evidence. So there is, I say, I mean, they're very consistent with my client's understanding that its evidential case was what the
Well, to be
inspector.
fair to you, the inspector goes on to say the evidence must be read in full as well.
Yes.
Yes.
Yes. As I say, consistent with my client's understanding that it was in this evidence, it was very clear, we say, and it would be dealt with by the inspector on that basis. It doesn't make it in any way less of a trump card for us, this issue, that we didn't labour it in closing. We didn't need to. Nor, indeed, that temporal time at the inquiry was spent on the obviously very technical capacity gap issue with all these different projections of waste, incredibly technical stuff. Our issue was really straightforward and obvious. Came down to what Ms. Tulay was saying. Look, it's out on a limb, Portland. It doesn't fit with the spatial strategy. It doesn't adhere to the proximity principle. However, as regards Dorset's closing, upon which my friends place a great deal of reliance now, Dorset made clear from the very start it maintained reason for refusal 1. That was the very first thing it said in its closing, and I do rely upon that. I also rely on what it said, and we can pick this up in the inspector's report at paragraph 6.132, where it's setting out what, under the heading spatial strategy, it's setting out its position on the spatial strategy. I refer, my lords, to the fact Dorset's position was very clear. The spatial strategy is not, the comparison is with that. It's not with what's happening now, as it were. It's with the spatial strategy. I'll invite my lords to read that, and also over the page, please. We have specific paragraphs of 6.134 and 135 about the proximity principle, all of which I say are very much issue stuff. As regards the Secretary of State's conditionally ceded issue, that I will come back to in reply, having heard my learned friend for the Secretary of State, if I may. My lords know we say that not only is it wrong, but it can't be run without a respondent's notice, that point. There's no respondent's notice for it. The judge clearly did not accept the Secretary of State's argument that the issue had been conditionally ceded. There's nothing to that effect in the judgment. That issue goes beyond the case that the Secretary of State actually pleaded that the issue wasn't a standalone issue but was wrapped up in the capacity issue, which I will come to shortly. But the final point on this chronological run through, I'd like my lords to know, and it is relevant to this conditional ceding argument from the Secretary of State, is that PPL's closing did two things of note. Firstly, it very much joined issue with Dorset and my clients on the issue, and for a reference for their inspector's report 8.25, which is where we see it join the issue, which is at core bundle page 4, 3, 6. The proposal supports the delivery of the waste plan spatial strategy, and it goes on, but it doesn't also, given that this PPL went after, of course went last, what this closing didn't say, what they didn't say to the inspector was, well look, Dorset have conceded that the issue if we make out our case on me, and one would have expected that had they understood the issue to be conditionally conceded, as the Secretary of State says. The PPL skeleton also, as my lords know, suggests that my client, through its counsel at the inquiry, Mr. McKay, should have made further closing submissions, having heard Dorset's closings. We say, really, this is a new point. Need evidence about what was precisely going on at the inquiry, but he didn't need to anyway, because our evidence was clear on the issue. So, I now turn to the decision. My lords, I've already looked at the decision, but if we just go through the nuts and bolts of it, the framework, and I'll explain why the reasoning on the issue is inadequate, in fact not there. So it begins with introductory matters, procedural matters, and then the site and the proposal and the planning history. We get to the inspector's summation of the most relevant policies of section 5. I take no issue with that. And we then have, as we've already been looking at, the inspector's recording of the parties' closing submissions, which is a very full recording, but confusingly has Dorset first, not my client, as actually happened. And I say again, because I do want to make sure I get this point across, there is concern here that the inspector, as the Secretary of State keeps telling us, the issue was conditionally conceded. The inspector may well have thought, as the Secretary of State is telling us, that my client had ceded the issue if the capacity gap issue went against it and Dorset, which it hadn't. But
Yes, thank you.
Yeah. He addresses third-party points and matters including conditions and the planning obligation, and then he sets out his conclusions at section 12, and that's where we will go now, if we may. So, core bundle, and this is very much the meat, of course, but with these important cross-references back. So, core bundle, page 477, he begins. In this part of the report, I've used references thus, bolded square brackets, to cross-refer to previous important paragraphs in the report, and in particular the relevant part of the main parties' cases. And these become crucial.
So can you say 477 you said?
477, my lord.
Sorry, thank you.
Yeah, I say the judge, learned judge, misses the significance of that, and we'll see why it's so important in a minute. We then have an introduction to what he's described as the main considerations for the determination of the appeal. A is whether the proposal would comply with the relevant policies of the Waste Plan 2019 and represent a sustainable form of waste management in relation to need, amongst other things, the waste issue. Now, pausing there, my lords, my client, assuming that was how the issue was formulated as it were at the start of the inquiry, my client had no reason to think that based on that formulation, the issue, which had been clearly framed in the evidence and the statement of common ground too, was not an issue. It's a very broad umbrella framing, as is common for inquiries. What we then find, though, is the first hints really, or indications that the inspector was thinking about this in a very different way from the parties, and certainly from the evidence. We have this indication that the inspector may not have grasped that the issue, our issue, was even an issue, because what the inspector goes on to explain is his understanding of the waste issue, and starting at we see at 12.5 running on, it's apparent he considered the waste issue to be about the soundness of the plan's assessment of the need capacity gap, i.e. the point that Dorset had raised after and distinct from its reasons for refusal, supplemented by consideration of whether the non-allocated site at Portland provided advantages over the allocated sites, i.e. the WP4A criteria. Not, and it just doesn't appear anywhere, not the issue concerning WP4C. What we can see the inspector do, having dealt with the capacity gap issue at paragraphs that run through to 12, the end of 12.12, we then find 12.13 at 479 the whole bundle. Workings of policy 4 require the decision maker to make a quality.
So can you give the reference again? I was just taking a note.
Sorry, my lord.
Can you give me the reference again?
12.13 at page 479.
Thank you very much.
So the inspector's now, he's dealt with the capacity gap issue. That finishes it finishes that finishes at 12.10, and then he discusses the allocation. It talks about the allocations, and he introduces policy 4. And then we get to his very bare bones description of what's going on with the allocation of 12.12. And then he says this at 12.13. The workings of policy 4 require the decision maker to make a qualitative comparison between the proposal at issue here and the allocated sites. If it can be concluded that the proposal provides advantages over the allocated site, then subject to other relevant policy, it could be found to comply with the waste plan. That is policy WP4A. It's clearly policy WP4A. He's very deliberately borrowing the words advantages.
Does it also accord with the council's formulation of the issue in the statement of common ground? The comparative point they raised.
The comparative point, to some extent, but it doesn't, but not entirely. Because the council formulation wasn't that formulation. It wasn't a WP4A formulation.
No, they said it was WP4C.
But went further than that, my lord, though, because the council's formulation was quite clearly about the spatial strategy as well. And this is I say very clear. What the council's formulation was not a mirror or a paraphrasing of WP4A. We've seen that, and it's clearly not. This clearly is a paraphrasing of WP4A. So the inspector, by now, we, as it were, are, in my estimation, rightly extremely concerned reading this report that somehow the issue under WP4C has dropped out, and our concerns are, unfortunately, and one can imagine when this landed, the stump lurch concern hitting home. They are made good when we get to having gone through the heritage and landscape points, and on the other matters actually comes to policy 4. I need to get there first though. So he first goes through heritage, then he goes through landscape, then at 12.74 on, so this is core bundle page 488, he considers a number of miscellaneous matters, other matters, and going through those, and we've got a list in our skeleton at paragraph 32, but he tackles perceived health impacts, then socioeconomic impacts, then impact on tourism and recreational activity, then whether the proposals would deliver shore power to cruise ships, then whether they deliver a district heating network, and then he comes to highways and climate impacts, and this is at 1290 at page 491 of the bundle, and these are paragraphs that the learned judge below relies on in the judgment, 1290 all the way down to 12.95. Now, what though, with respect, the judge missed what the inspector is clearly doing here. The inspector is, as the internal references make clear, and as the surrounding paragraphs make clear, he is not dealing with WP4 here, not remotely. He is dealing with points about traffic impacts and points about climate, carbon. So, and his internal references, as regards 12.95, which is a point that my learned friends, the judge and my learned friend rely on considerably, because it mentions waste miles. It says the evidence is clear that burning residual waste in this location would result in lower carbon emissions than the present situation, where the waste authority disposes of its residual waste partly through landfill and partly through incineration outside the waste plan area, with the consequent waste miles. So they say, well, look, here he is. He's addressing the proximity principle point. He's addressing WP4C, but he's not. The internal references are very clear. He's very clearly set them out here. They are, as my lords will see when my lords follow them, and please do, they are to bits of Dorset and Portland Powerfuel's closings that are not at all, they are not about WP4. They are, as the inspector is clearly telling us, they're about carbon. Now, carbon emissions, greenhouse gas emissions, they're a very important topic, of course, but they're not the same as the proximity principle.
But are they an aspect of the proximity principle?
They are, I accept, my lord, they are an aspect. Yes, they are, but they're only an aspect, and that's why, and I don't understand this to be controversial, I make the point that there's a lot more involved in HGVs driving extra miles than just their carbon emissions. Many, as my lord knows, many planning harms that are not to do with their greenhouse gas emissions, risk of accidents, risk noise. One can go on. Carbon is a discrete and distinct topic with a small overlap, but it's only a small overlap.
Yeah, but if the inspector is concluding that there's going to be a reduction in waste miles, that will be a reduction in waste miles for all purposes, even if he only mentions carbon at this stage.
And this, my lord, is where the distinction between a comparison between the spatial strategy and the proposals, and between this is what's happening now.
Yes, that's another point.
Absolutely crucial, but it's the crucial point, of course, because policy, as we've seen, policy 4C is about the spatial strategy, and the spatial strategy says primarily southeast Dorset and so on. This exercise, this carbon exercise, is about what is happening now, and the comparison between what is happening now and the proposals in terms of the difference in carbon emissions. It's a distinct, conceptually distinct matter. Clearly it is. What is happening now is different to the spatial strategy.
This is the point that I want to make sure I understand this. This is the point the council is raising in their case.
Yes.
But for our purposes, does this matter amount to an argument that you can't take into account what's happening on the ground when you come to apply policy WP4? Because if that were to be the argument, it would be a misinterpretation of policy argument. But that's not the case that's been run against this decision.
Well, we can't. It's not been run because we can't see. The inspector doesn't say enough about any of any of the relevant policy aspects of the issue.
Give me,
to say-
I don't follow this.
Yeah.
It's clear, and you criticise this,
Yes.
as looking at the situation on the ground, what's actually happening, as opposed to what the plan would
Yeah.
aspire to.
Yeah.
But that leads logically to the question, is it being suggested, has it been suggested, that that is a misapplication of policy and there in effect a misinterpretation? Because if that were to be the argument, certainly not being run by Dorset in this case, one would expect that to be raised in the pleadings, but I've not seen it
No.
put that way.
My lord, it's clearly my fault. I am not making myself clear. I'm not criticising the inspector for, in his carbon greenhouse gas analysis, comparing the proposals against the status quo. No. Had the inspector said, under policy WP4C, I compare the proposals with the status quo, yes, I would be saying, and I would have pleaded, that is a misunderstanding of policy because you've misunderstood the spatial strategy. But the inspector's not saying that. He's not. The inspector is, he makes completely clear, not dealing with policy WP4 here. He's dealing with distinct question of carbon emissions and whether carbon emissions would be reduced by comparison with the status quo. And I don't criticise that. What I criticise, as I'll come on to very shortly, is when he does get to WP4, he just does not tackle WP4C. Not as against these proposals. And we can see from the paragraphs that follow immediately after this paragraph 12.95, that he's immediately making clear he's not dealing with WP4 here. Because he says 12.96, as far as a comparison with the approach of the Waste Plan 2019 is concerned, the situation is more complex. For reasons that will come clear, I deal with that below. He then wraps up on the other matters, and he says, under overall, gets confusing because under overall balance and conclusions, he's in fact dealing with stuff that's new. He hasn't dealt with it before. Overall
But
balance.
does that matter if it's,
No.
if it's otherwise?
No, of course it doesn't.
No.
Of course it doesn't, my lord. But what he then does here is he runs through what he's concluded on landscape, visual and heritage, and the other matters. He wraps it up, 12.98. He says 12.99, on that basis, I'm content proposed complies with this run of policies. And my lords will note, policies 4 and policy 1 are not there at 12.99. He then says, that said, there is policy 4 of the Waste Plan 2019 to consider. And this is where we find, such that it is, his reasoning on WP4, which, as I hope I've explained to my lords, he makes crystal clear this is where he's tackling it. And what he says is, at 12.100, the clearest possible paraphrasing of WP4A. As I've set out above, this allows proposals for the waste management facilities to come forward on non-allocated sites where the non-allocated site provides advantages over the allocated sites. It is WP4A. It is nothing else. He explains he's got to do a comparative exercise. He says it's unusual. And then he goes through that WP4A comparative exercise, concentrating on the 2 allocated sites, only 2, mark my lords, only 2, not all the 4 allocations.
That's not the subject of legal criticism, is it?
No, I don't criticise how he deals with WP4A. No.
But the fact that he went for 2 rather than 4 is not the subject of challenge, is it?
Not under WP4A. Sorry, I'm raising it, my lord, because it's another indication that he's not. doing the WP4C exercise here. If he'd gone for all four, there might have been a basis for my learned friends to say, well, he is doing the WP4C exercise because we've got the whole spatial strategy cast of allocated sites here, but he's not doing that. He's not asking himself, right, what does the spatial strategy say? What does it allocate? Is this proposal achieving, if it falls outside those allocations, a good spatial distribution of facilities? He's not doing that. He's doing the WP4A comparative exercise against two particular allocated sites, Parley first, then Camford. So that's how he does it. And my lords will see he does it he's very clear. He deals with Parley first. Does it very clearly, and what my lords can see that he's dealing with the range of issues. He can't cope with alone with residual waste, and it's in the green belt. The appeal site has obvious advantages over that. Can take place without landscape or heritage harm. He does Parley. Then he moves to Camford, and he does the same thing. He's comparing across the whole board of possible planning considerations the advantages, disadvantages of the appeal as opposed to this allocated site. And that runs all the way through to the end of 12.109, where he wraps up on his comparison. Please, my lords, read all of those paragraphs. And I would like to draw my lord's attention to, particularly, is what he says. He's still in his Camford comparison at 12.108. He says, I do not doubt that the proposal at Camford Magna might well perform better in terms of the spatial strategy of the waste plan. But that would have to be balanced against the Greenbelt half, to which substantial weight would have to be attached than any other half. To complicate matters further in terms of the spatial strategy, the locational benefits of the Camford Magna site might well be offset. And he goes on. Well, he's making it entirely clear that he's considering Camford. He considers Camford Magna to have as a site that might perform better in terms of the spatial strategy. He's describing it as having locational benefits compared to the appeal proposals. The indications, insofar as one can take indications from this, and I can't push it too far because it's Delphic and it's very cautious, but so far as one can take indications from this, it's that had the inspector applied his mind to the issue, does this proposal at Portland support the spatial strategy? Does it adhere to the proximity, in particular by adhering to the proximity principle? The implication from these things he said here about Camford is that, well, he might well have answered no. No, it doesn't. But I can't push it too hard because he says so very little. What I can say, and I absolutely do say, is that this is all in the clearest possible terms. It's the WP4A exercise. It's not the WP4C exercise. It's not the issue. And does it raise a substantial doubt that the inspector has missed something material, got something wrong? Well, absolutely it does. And I say again, I rely heavily on the case that the Secretary of State has run throughout this challenge, that the issue was conditionally conceded. Somehow the issue has completely dropped off the inspector's radar, despite being there very clearly in the evidence, not least from that part. And it's really inexplicable, and we are convinced that had he actually dealt with the issue, we had the fairest crack of the whip at getting a conclusion that no, the proposal couldn't comply with WP4C. And of course, if it couldn't comply with WP4C, it couldn't comply with WP4 as a whole. But instead, the inspector he's treated it as if it's just not an issue at all.
Can I,
Yes.
when you were taking us through the waste plan,
Yes, Mike.
you summarised what the spatial strategy is. What do we need and where is it going to be?
I think, yes, that was their words, wasn't it, my lord, I think.
Yeah, effectively.
Yeah.
So why is the inspector doing anything wrong when he says, well, first I have to decide what's needed. Well, I take that from the waste plan and I reject the council's argument that I can reconsider how much is needed. And there's a question where it's going to be. Well, I can see what's in the plan is 4 allocated sites, but I look at those sites, none of them is as good as the appeal site for the various reasons. So the appeal site obviously does deliver the aspects of a spatial strategy that are contributing to meeting the needs identified in the plan. It moves waste up the waste hierarchy, it deals with that. The only remaining question is where? What's wrong with saying, well, when it comes to where, look at what's allocated in the plan, but this is better. Well, that gives me the answer to where. Now, obviously, the proximity principle says, well, you want it to be as close as possible, but if it's a question between here or there, and I think there is better than here, that is as close as possible. What's wrong with that? In other words, you've read the report as if he's just addressing 4L and just doesn't address 4C at all. But it's not obvious to me that that's really a fair reading of the report. He's taking policy 4 as a whole. And policy 4 as a whole is, when can you prefer an unallocated site to an allocated site? And what you have to do, which is what we're told earlier, is you look at how much is needed and where it should be. And when you're asking where it should be, why can't you just say, that is a question in the end. What's wrong with the allocated sites? Why is this proposed appeal site better than the allocated sites? And if you conclude that it is, then it does satisfy policy 4. So I'm a little bit uneasy about sort of dividing up policy 4 into this bit, this bit, this bit, and this bit, into this bit, this bit, this bit. Isn't that taking too sort of legalistic a view of what's going on, which we're told repeatedly you shouldn't do?
Shouldn't do. What, my lord, with greatest respect, no, because the policy 4 wording is for better or for worse. It is what it is on the page. We have, I focus on the A and the C. We have this comparison. And the comparison, as I said, can range far and wide across planning considerations. But C is, for better or worse, very specifically about the spatial strategy. The problem with the approach my lord has outlined as the one the inspector follows is that the inspector cannot get to an answer to C if all that he does is look at advantages and disadvantages under A. Not consistent with WP4. He might get there consistent with common sense, perhaps, a sensible approach, but he'd have to get there by a rather roundabout route. He'd have to find that under WP4C, no, this proposal it can't show that it supports the spatial strategy by ... adhering to the proximity principle. Can't show that because, and the proximity principle is this really precise thing, which is why I took my lord to it at 316 in the waste plan. It's really precise thing, managing the waste as close as one possibly can to where it arises. And we know where the waste is. It's all, looking at the map from where my lord is, it's all down here in the southeast corner around Bournemouth, Christchurch and Port. So with the best will in the world for this proposal, even if this proposal, as the inspector clearly found, had very few heritage harms, despite the great array of heritage harms that were to be possible to be considered, and landscape harms similarly, it couldn't in that way pull itself closer to where the waste is. Just physical fact of where the waste is, nor could it somehow by a side wind, not that this is actually, I'll argue, but by the fact that it's on the coast. So if someone was bringing waste to it from the coast, well, it'd be better by ship. That would be better, because the waste is over in Bournemouth, Christchurch and Portland. It's not coming out on ships from there. It's coming through Camphor Resource Park in fact. So it couldn't, by its other advantages, whatever they are, and it didn't, and the inspector doesn't say it did. In fact, he says the opposite. It couldn't, by those other advantages, bring itself as adhering to the proximity principle. And this is why 12.108 is quite important, because there he's saying, well, Camford better. Sorry, I paraphrase, but he's pointing out the Camford advantages in terms of the spatial strategy and locational benefits, as opposed to the appeal side. What the inspector could have done, my lord, and I entirely accept he doesn't do this. What he could have done is he could have said, okay, there is a failure to comply with policy 4C, but and so overall there's a failure to comply with policy 4, but that's one policy of the waste plan, although it's a very important policy. And standing back from everything, my job as the planning decision maker, and then the Secretary of State is the ultimate decision maker, is to apply the statutory test and determine in accordance with the development pattern unless material considerations indicate otherwise. And I consider those other material considerations are so weighty, so powerful, that permission should nonetheless be granted, despite non-compliance with important policy in the waste plan. So he could have, yes, he could have done it. We're in the realms of pure speculation because he didn't. And this, my lord, absolutely hits the nail square upon the head. This is the crux of things. I say, and I will say again, one cannot, by doing the WP4A comparative exercise as the inspector did, and the conclusions he reached on it, get to a WP4C exercise and compliance with WP4C. I will accept if he'd said at 12.108, well, comparing with Camford, this proposal would perform better in terms of the spatial strategy. This proposal has locational advantages. I would be on an incredibly sticky wicket. But he didn't. He said the opposite of that. So this is why I say that there is no. It's not just there's no adequate reasoning on the issue. He just doesn't deal with the issue at all in his report, and the Secretary of State then, of course, adopts everything. So far as relevant, she did adopt everything. The only final point I make on the decision itself is that the decision was made. It was made to say, and this is a very tangential point, so apologies for introducing it, but I just would cover it off. The decision was made at a point in time before the officers reported on the Camford proposal, which was reported on literally a matter of days before the Secretary of State made her decision. It was argued below, suggested below orally, that one way that the inspector was reasoning here was that these Portland proposals support the spatial strategy because the spatial strategy was not delivering. Now, I've taken my lords early on in 12 to the bit of 12 where the inspector notes that the allocations hadn't come forward to date. In my submission, one cannot take from this report that suggested line of reasoning. It's just not there. The inspector is not saying implicitly or explicitly these Portland proposals support the spatial strategy because the spatial strategy hasn't delivered. However, if my lords were to find that is what the report is saying, then that would raise immediately a problem for the Secretary of State in defending the decision, because the officer's recommendation of planning permission for the Camphor proposal would then be an obvious, I say, material consideration and a weighty one that then came in before the Secretary of State's decision that she would then have had to grapple meaningfully with. But as I say, this report is not reasoning on the basis that the Portland proposals support the spatial strategy, because the spatial strategy hasn't delivered the allocations yet. I hope that's clear as it can be, tangential though it is.
The paragraphs on Canford we've been reading in the inspector's report discuss greenbelt issues,
Yes.
and the inspector, I imagine, has to be careful not to say too much in case it's then quoted back when dealing with a Canford application. He hasn't got it in front of him. But
Yeah.
nonetheless, he is referring to this, and isn't he saying there are very real difficulties with Canford in greenbelt terms? And he goes so far as to say it might only support a smaller facility than that proposed. So isn't that something he's taking into account in the balance when looking at the proximity principle? That in the real world, you may not get a permission at Canford, or indeed, or alternatively, one for such a large facility. And that goes to the need case and meeting it.
What my submission?
Have I misread?
In my submission, yes, that is not what he is doing here.
Then why is he going into greenbelt? Why bother with it at all?
Because he's doing the WP4A exercise, the comparative advantages exercise across the whole range.
Yeah, but you
of
wouldn't bother to do
planning
that if you
matters.
thought Canford was going to get permission in any event. It'd be a waste of time. You'd be doing a theoretical comparison. This is better than A is better than B. But so what if the allocated site's going to get planning permission?
He says, my lord, in the clearest possible terms, the waste plan requires me to do this exercise at 12100 again. Unusually, these decision maker must carry out that paragraph we went to. He's taking on the challenge set by WP4A, taking it on full on, and he goes for it.
And indeed, it arose from the statement of common ground.
What?
The comparative exercise the council referred to.
But sorry, but that statement of common ground, the comparative exercise the council referred to, was one that clearly went beyond the WP4. It was distinct to and different from the WP4A exercise because that was about a comparison correctly under WP4C with the spatial strategy, which has 4 allocated sites and this general preference for sites in southeast Dorset, and if not in the allocated sites, then a good spatial distribution of facilities. That's how the issue was framed in the statement of common ground. It wasn't framed as a WP4A exercise. And in any event, as I say again, that was the Dorset PPL statement of common ground, not my client's. I mean, this is one of the oddities, of course, of the inquiry system and the Rule 6 status system. My client had the full status of as a party, but as a matter, we'll dig out the statutory instrument. But what almost always tends to happen is that the council and the appellant agree a statement of common ground between them, and it happened in this case clearly. So again, in answer to my lord's question, no, I mean, being as flexible and as generous as is humanly possible, the issue, does this proposal support the strategy, in particular adhering to the proximity principle, is just not tackled in this report. And it's the first, it really does jump out in my submission, jumps out of one. Now, it's 20 to 1, and I haven't tackled where it is, why it is we say, specifically tackled why it is we say the judge got it wrong, why the things that she relied upon below not in fact save this decision and demonstrate adequate reasoning. They are wrapped up in the points that we have been discussing. So I would be repeating to some extent. I don't want to do that. I also haven't addressed my lords on two points that I would like to address my lords on, which I say are relevant from the proceedings below. May I proceed?
Yes.
Thank you very much. The first point, which I have already made, but I want to give my lord some references, is the way that the Secretary of State consistently argued that this issue was wrapped up in the question of need, and I say that, as I've said, that gives us a big clue as to why the inspector missed it. And the references to that, and I'm going to give them to my lords chronologically, starting with the statement of facts and grounds. I'm not going to take my lords to the references if that's acceptable, but the ground one text starts at para 62, and then the
Sorry,
essence,
wait a minute. Where are we?
sorry, core bundle 336. This is a statement of facts and grounds, but if my lords could just go to para 74 at 338, and my lords will there see the essence of ground one, and the contest between the parties over WP policy concerning the spatial strategy and the proximity principle made it of particular importance that the inspector and address the issues of whether the Portland proposals complied with Part C of WP4, and then continues over the page.
Yes.
That's just to introduce the way it was set out in the statement of facts and grounds. We then have the Secretary of State's summary grounds of resistance, and if my lord could please turn to page 277, my lords will see at the very first opportunity, as it were, what the Secretary of State argues, and turning the page over at 278, one sees paragraph 24, and my lords will see immediately, and with heavy reliance on the Dorset closing submissions, the Secretary of State's argument that the issue issues were in fact, quotes, intimately connected with the fundamental dispute about the need for residual waste management. I'm simply taking my lords there to see that this was the Secretary of State's case throughout, and that we immediately, in our reply, and this is at 254, in the core bundle, took issue with that. And at the very outset, 254, paragraphs 2 and 3, and we then went on to elaborate upon that. But the point is that this dispute about whether the issue even was a principal important controversial issue was there at the start. Issue was joined upon it, and it continued throughout. And in fact, in oral submissions, my own friend for the Secretary of State then introduced this development to the point that the issue had been conditionally ceded. If the waste capacity issue was lost, as it were, our issue had been conditionally conceded. A lot of time was taken on this before the judge. The judge clearly didn't find the Secretary of State on this, but I do criticise the judge for missing the significance of this, because I do say that this is an unusual case where the decision maker is telling us, not through a witness statement from the inspector, but through her pleading, is actually telling us why there isn't any reasoning on the issue. Because the decision maker thought it was wrapped up with something else, and in fact, and fell with it, was conditionally conceded, which was wrong. But one couldn't have, in my submission, a clearer clue, a clearer demonstration, making sense of everything, that there isn't any reasoning on this issue. So that was the first point. The second point concerns the dispute that we had below, but not interestingly about at the appeal, about, or not to the same extent, about the spatial strategy, which I say has coloured certainly the judge has rolled them all up together. It's coloured her approach to this question of was the reasoning adequate. And this was a dispute there were two parts to it. Firstly, what is the spatial strategy? And secondly, whether, which is my client's case, the spatial strategy has at its heart spatial matters and the proximity principle, or whether, as the judge found, accepting my own friend's submissions, it ranged across many different areas and didn't have those things at its heart. I've taken, my lords,
Is
to
that last point of criticism, paragraph 90 of the judgment?
yes, it is, my lord, isn't it? Sorry, it is paragraph 90, isn't it? Where the judge said the spatial strategy
6
covers
points.
six points. And yes, in terms of the first point, I've already taken, my lords, to the relevant introductory paragraphs to the spatial strategy, those paragraphs 5.1 through to 5.4, and we've looked at the spatial strategy itself. What the judge didn't accept in my submission, she should have done, and could we please just go to look at this one more time in the supplementary bundle at page 30, is that this paragraph, these paragraphs 5.1 down to 5.4. At 5.2, as I say, where it says the spatial strategy builds on from the vision and objectives, and I interpose we looked at the vision and objectives, seeking to move waste up the waste hierarchy, support the proximity principle and promote self-sufficiency. Those words they're describing what the vision and objectives are trying to do. And it's the word through and onwards that explains what the spatial strategy is doing. And that makes perfect sense, because yes, we've got the vision, we've got the objectives, we've got the needs identified elsewhere in the waste plan. The spatial strategy is telling us how, as my lord Nugee said, how, where and what we're going to address those things. That's what the spatial strategy does, and it does it over these bolded pinky orangey pages that follow immediately afterwards. It's not the case. My learned friends for PPL say at paragraph 21 of their skeleton, they say, and I quote, the final sentence of paragraph 5.3 shows that the spatial strategy was then translated into the specific policies of the waste plan, such as policies 3, 4, 6, 4, 14, 19 and 21, and it is the policies themselves that embody the spatial strategy. That's wrong. That's not what 5.3 is saying. The final sentence of that says the detail and justification for the spatial strategy is provided in the chapters that follow. The detail of the spatial strategy is provided immediately over leaf. The justification, yes, is set out throughout. The justification, here are the needs, these are the capacity gaps, and so on. That's provided over other parts of the waste plan, as are the allocations themselves, the detail. But what is not happening here, because it would be entirely circular, is the spatial strategy is not something, as PPL says, that is actually set out across the waste plan. Spatial strategy is set out in these bolded parts, the yellowy, the orangey shading over 31 to 33. It would be, of course, entirely circular were it as PPL say, because if the spatial strategy were embodied in the policies, were set out in the policies, it would make no sense for the policies to set tests by reference to the spatial strategy, which is what they do. And WP4C is a prime example. It would be entirely circular. So that's the first point. I don't say the decision gets that wrong. It doesn't say enough about the spatial strategy for me to say one way or the other, frankly. But clearly the judge accepted my own friend's submissions on that. I do say that she was wrong to do so. The second is this question of, is the spatial strategy at heart a spatial strategy? Or is it about in fact, equally all the other things the judge found referring the learning friend submissions at paragraph 90. And I submit it is clearly at heart spatial strategy. Other parts of the plan identify the needs in great detail, section 7. The spatial strategy and those allocation insets are about the detail of where we're putting things and what we're putting in those things to meet the needs. And I do say that by diminishing the importance of the spatial strategy being a spatial one about space, where things go on a map, the judge has missed a point that does colour the way she approaches the question of adequate reasoning. Albeit, and I say this too, albeit that who was right or wrong about what the spatial strategy was really about is not determinative of whether or not determinative, might be relevant, but not determinative of whether or not the decision has adequate reasoning on the issue. Not determinative of it. So, again, I can't say the decision is explicitly wrong in its understanding of the spatial strategy because it doesn't say enough about it to know. What can be said is that given the way the Secretary of State explains that the issue wasn't standalone and had been judicially seeded, it does seem, the Secretary of State is saying, the inspector was in fact finding that the spatial strategy was about meeting need wherever one met that need spatially. Now, I don't, for myself, submit that's what the decision does. It doesn't really come across clearly at all. If that is what the decision's doing, it's wrong. A misunderstanding of the waste plan. But this all becomes quite hypothetical, frankly. Those are those two discrete points. Final topic is why is the judge wrong? Why is the judge wrong? In our skeleton, we break the judge's approach down into 5 different aspects. And looking at my learned friend's skeletons, they don't appear to materially disagree with us about 5 different aspects. The judge found that there was adequate reasoning relying on these 5 aspects, and she was wrong to do so. The first aspect was the judge found that the inspector accurately cited various waste plan policies, so it should be assumed his application of those policies was correct, and this is judgment paragraph 76 and 78. But as we say, accurate citation of policies doesn't mean that the inspector correctly understood the issues or the evidence, or correctly applied the policy to that evidential matrix. That is not in fact taking the decision to the safe harbour of adequate reasoning. The next aspect the judge relied on was that the inspector correctly identified the waste issue as broader than reason for refusal 1, encompassing the capacity gap issue that Dorset made a primary submission on. And the inspector, of course, then rejected that capacity gap argument from Dorset. But as I've explained, whether or not there was a capacity gap for these proposals was clearly distinct from the question of whether or not these proposals would address that gap in a way that supported the delivery of the spatial strategy, and in particular adhere to the proximity principle. So that doesn't get, again, the decision to the safe harbour, doesn't in fact support the judge's conclusion that there was adequate reason to justify that conclusion. The third aspect is that the inspector and the Secretary were required to and did consider the non-locational aspects of the spatial strategy, such as promoting self-sufficiency and addressing that need, and they were entitled to prioritise those aspects. But again, whether they met the need, didn't and address self-sufficiency, couldn't get one out from needing to consider the question of does it support the spatial strategy, ... in particular adhering to the proximity principle? One's still got to grapple with the issue. Here, really, the judge is perhaps allowing her interpretation of the spatial strategy, which was skewed against spatial, to influence her wrongly. The fourth aspect she relied upon is the inspector's conclusion on other matters, and in particular those conclusions that we've looked at about waste miles at 12.95 in the report. But I've shown, my lord, those are not about our issue, they're about something distinct, as the inspector's very careful internal references make clear. And then the fifth aspect, of course, is the WP4A comparative exercise. But we've been through that. I've shown, my lord, it is a WP4A comparative exercise, and it's not the WP4C exercise about supporting the spatial strategy, in particular adhering to the proximity principle. So that too doesn't get the decision, as it were, home. And we've been through all of that in some considerable detail. Have we been substantially prejudiced by this lack of adequate reasoning? Well, in my submission, it's so obvious that we have, because we made this a big part of our case. We were a full party at the inquiry, as was our co-party, the Portland Association. To not have the issue addressed leaves us with a yawning doubt as to whether the inspector got a really big thing really genuinely wrong. May I turn it back?
Yes. Any more questions? Okay.
My lords, those are my submissions.
You said a moment ago that the judge skewed the correct understanding of the spatial strategy. And I was wondering whether you had in mind paragraph 90 of her judgment. You said that you were going to criticise that, but
Yes.
I'm not sure I've heard you say why it's wrong.
Sorry, my lord, I was going quite quickly to ensure I finished by 1 o'clock.
But what's wrong with 90?
So what
is the short
Yes,
question?
the short answer. Let me just make sure I've got 90 up before I say
Page 118 of the core
before
file.
I say something completely on point. So the short point of what is wrong with 90, and it's reflected elsewhere in the judgment, is that it fails to reflect the importance and the significance that the spatial strategy attaches to putting things in the right place, the right space. It is a spatial strategy. What the judge is doing here is making the spatial strategy something that covers, in fact, the sweep of the vision of and the objectives. Whereas the vision and the objectives, which cover all these points, they're elsewhere in the plan. The spatial strategy is about having set out those the vision, set out those objectives.
Isn't she just summarising what she's been quoting in 87 and so on? I mean, a lot of these expressions you can find in the spatial strategy quotations, 5.1, 5.2 and so on.
Well, my
So
lord, I've obviously gone too.
commendably succinct.
I've obviously gone too quickly, but my point about those paragraphs is they are introducing the spatial strategy. They are talking about other things in addition to what the spatial strategy is doing. And what they say about the spatial strategy itself per se is narrower. What they say about the spatial strategy itself per se is, for example, the final bit of 5.2, through making provision for a range of sustainable waste management facilities in appropriate locations. The rest of 5.2 is about what the vision and the principles are about. And this is, as one would expect, explaining that the spatial strategy is a spatial strategy within the plan that tells us, is primarily concerned to say that where the things should go, what they should be and where they should go. not about the range of vision and objectives. It's a sub point, my lord. As I say, it doesn't. Who is right or wrong when interpretation of spatial strategy is not determinative of the core issue of whether there is adequate reasoning on the issue. Even if we are wrong, it doesn't mean we lose.
Thank you very much. We'll start again at 2 o'clock.
All rise is able.